Good afternoon, everyone. Again, let's start. My name is Baldev Pinder. Thank you for joining our webinar. We're doing it. We're quite pleased to do it today in conjunction with our friends from Holman, Fenwick and William. This is we've got Adam Richardson from Holman, Fenwick, William, who does shipping and commodities. We've got my colleague Ramandeep Kaur, who will be assisting on this webinar as well and speaking on some of the cases that we've come across. I just want to make a short introduction in terms of today's topic and in terms of the structure of the webinar going for the next hour. Maybe we can start with the next screen, Raman. The webinar today has to do with misdelivery claims, and in particular, we're going to focus on two Singapore cases that have come out in the last 2 years and two English cases that have come out from the English courts in the last 2 years. They deal with misdelivery claims, and the reason why we think it is interesting to talk about these cases, and if you bear with us, both Raman and Adam will go into some detail into the cases because it is relevant, and I think it will be interesting for lenders, traders, and ship owners to look at how BLs are being used and how to keep them used as the right form of security. Before we talk about the Singapore cases, after we talk about the Singapore cases, Adam will then talk about the UK cases. There are two cases that have gone on in 2022 and 2021, and subsequently that will be 15 minutes each. And so at about past, we will then have a Q&A session where Adam and myself will take questions on what these cases mean in terms of the practical effect it will have for lenders and for traders. But before I give the floor over to Raman, let me just, for the benefit of the audience, let me just give some context as to where does misdelivery claims arise and what is that context. I've put on the screen, as usual with all my webinars, very fun, colorful diagrams as to the flow of documents and the flow of the goods. Like all things in life, bear in mind that the BL moves in parallel for two streams. It needs to be used as a financing document. It also needs to be used as an operational document to move goods on and off a ship. That's the concept of a BL, and the two don't always sit neatly. I've put in the diagram before us the movement of goods at the bottom, where you've got a shipper who then ships the goods. The goods is placed onto a vessel. You've got a ship owner in green. That ship owner will then charter the vessel to a seller, an intermediate buyer in orange, who then sells off to the receiver in the light pink box. The receiver then has financing, and the receiver then sells it on to an end buyer. The movement of the BL is, for most parts, a lateral movement from left to right, from shipper, charterer, receiver, and then to end buyer. But because the BL is being financed, the BL also then moves up to a financing bank, and that's the box in yellow that you look over there. So in terms of all the difficulties that happen with misdelivery claims, think about it as a bifurcation from the point of view of the receiver between the receiver box and the financing box. That's where if BLs go up, they then cannot go right. And in the cases that we've looked at in the past 2 years, the Singapore cases in particular, they deal with the Hin Leong collapse and how BLs have arrived back at the lending bank and their use of the BL to sue the ship owner. As a basic premise, might not be obvious to everyone, but as a basic premise, the BL is an important document because it gives you a right of suit. It gives you a right of possession to the goods. So the lawful holder of the BL, whether it's the bank, whether it's an end buyer, whether anyone who shows up to the ship owner and says, please give me the goods, and the ship owner is unable to give the goods because they have discharged it to the end buyer, then there is a claim for misdelivery. And misdelivery claims are notoriously difficult to defend against because there isn't very much to be said against it. There has been a slight change in wind. I will let Raman and Adam explain that for both the Singapore and English law perspective. Raman, the floor is yours.
Thank you, Baldev. Hi, everyone. As Baldev mentioned, I'll be covering the two Singapore cases. The first case is the STI Orchard. This was a claim by OCBC against the owner or demise charterer of the STI Orchard. OCBC here had financed Hin Leong's purchase of cargo shipped on board the vessel STI Orchard. Hin Leong failed to reimburse OCBC, leading OCBC to commence a suit against the ship owner for delivery of the cargo to Hin Leong without the presentation of the BLs. The ship OCBC sought summary judgment in the sum of some 13.6 million US against the ship owner for misdelivery, but was unsuccessful. And the court granted owners unconditional leave to defend, as there were issues which the owner was found to have raised which merited further investigation. I'll briefly cover the facts. I've tried to lay out the key facts by way of this diagram in this slide. So OCBC's it's clear that the owner of the STI Orchard had passed on the bills of lading to the charterer, who in this case was Winson. Winson in turn had a sale contract with Hin Leong, and Hin Leong had a financing arrangement with OCBC, who had granted an LC to finance this purchase of the cargo by Hin Leong. Now, OCBC's LC application form provided that if its customer required the seller to present BLs to obtain payment under the LC, the BLs were to be made out to the order of OCBC. When applying for the LC, however, Hin Leong specified in its instructions to OCBC that its seller, that is Winson, was to present the BLs endorsed to the order of Hin Leong instead of OCBC. Now, OCBC accepted this slight tweak and it issued the LC, payment under which was to be made against the presentation of, among other things, BLs endorsed to the order of Hin Leong. The LC also provided that if the BLs were not available, an LOI issued by Winson to Hin Leong on the terms set out in the LC could be presented instead. Now, on 12th March 2020, Winson's bank, which was ING in this case, presented an LOI to obtain payment to OCBC. OCBC sought Hin Leong's confirmation as to the acceptability of the presented documents. Hin Leong confirmed and requested OCBC to grant it a trust receipt from 3rd April to 28th April for the sum that was due under the LC. OCBC immediately granted that trust receipt loan. Meanwhile, the cargo had already been delivered to Hin Leong between 5th and 6th March in Malaysia without the presentation of the original bills of lading. Now, on 10th April, very soon after, Hin Leong appointed advisors to restructure itself, shortly after which it informed its lenders of its dire financial position. And on the same day, OCBC alleged various defaults and demanded immediate payment of the trust receipt loan. OCBC demanded that the seller, Winson, deliver the original BLs, which the seller duly did. The BLs were, however, as provided for under the LC, endorsed to the order of Hin Leong. OCBC got the BLs endorsed in its favor from the judicial manager of Hin Leong. And after that, it commenced an action for misdelivery against the owner and applied for summary judgment. Now, to resist summary judgment, and this is an important point, which I do want to make, the owner only had to raise triable issues of fact. So this case is not the final verdict on misdelivery claims in Singapore. All that this case and the other case that I will also move on to, SAB and Merck, all these cases show is in what circumstances can a summary judgment be defended. But the cases still show us the overall direction in which misdelivery cases probably are headed in Singapore, because the court's reasoning is quite detailed and by reference to established principles. To resist the summary judgment in this case, the owner raised tribal issues on 2 counts here. First, it argued that OCBC had not become a holder of the BLs in good faith. And second, that OCBC had consented or authorized to the delivery of the cargo without the presentation of the BLs. The court was satisfied that these tribal issues had been raised, and it granted the owner unconditional leave to defend the claim. Now, on good faith, the key findings of the court were as follows. First, the court found that Hin Leong, OCBC, I do apologize, did not intend to rely on the BLs as security at the time that it financed Hin Leong's purchase of the cargo. And in reaching this conclusion, the court took note of the following facts. First, it examined the underlying arrangements, the financing arrangements pursuant to which OCBC advanced the monies to Hin Leong, and it found that they did not suggest that OCBC intended to take a pledge over the BLs. Now, a pledge over the BLs only constitutes a pledge of goods if the possession of the BLs constitutes constructive possession of the goods themselves. And for this, a financing bank must ensure that the BLs are made to its order or endorsed in blank. Otherwise, constructive possession is not gained and a transfer of the BLs is not effective to constitute a pledge over the goods. Here, as we noted when covering the facts, OCBC had acceded to Hin Leong's request for the BLs to be endorsed to Hin Leong instead of to OCBC at the time that it was issuing the LC. It also did not ask for any endorsement of the BLs to OCBC at the time that it issued the trust receipt loan to Hin Leong. Next, the court also found that the underlying arrangements suggested that OCBC instead looked to the proceeds of the sales as collateral under the trust receipt loan. OCBC was found to know, or at least have noticed, that Hin Leong intended to blend the cargo that it had bought from Winson for onward sale to Pertamina. And the basis on which the court made this finding was that Hin Leong had provided OCBC with a copy of its sale contract onwards to Pertamina, which had identified the sale product as a different product to the one that it was purchasing from Winson. So in this case, the court found that new BLs would have been issued for the purposes of the on sale, and OCBC could not have been relying on the BLs that must have been that Hin Leong would have received under the sale from Winson to itself as security for the financing. Third, the court also took note of the fact that OCBC only tried to perfect its security by having the BLs endorsed to it after it discovered Hin Leong's financial difficulties, by which time the cargo had already been discharged and apparently blended into a new product for on sale under the trust receipt loan. It was queried in the circumstances whether it was even possible to create a security interest in BLs, which would be contrary to the agreed arrangement of the parties. So taking all these factors in the round, the court found that it was at the very least arguable that OCBC did not meet the threshold for honest conduct, which was required for good faith, because it did not look to the BLs as security at the time it financed the cargo and was now attempting to bring a claim on such purported security. The second key point on which the owner managed to raise a triable issue meriting a full trial is the defense of consent to misdelivery. In very simple terms, what this defense means is it concerns a situation where a BL holder gives instructions to a ship owner or is deemed to have done so, which the ship owner then acts upon such that the BL holder cannot complain against it for having misdelivered the cargo. It also covers situations where instructions emanate from a person who was not the holder of the BLs at the time of delivery, but subsequently became a holder. This defense is generally very hard to prove and has rarely succeeded, even in situations where the fact that the underlying goods would be delivered against an LOI may be known to a bank, but may be known to a bank. Even such knowledge per se has been held not to constitute consent to delivery without the production of BLs, because banks, the courts have reasoned, are entitled to rely on a carrier's contractual promise to deliver against the production of BLs, and they expect the carriers to have an LOI to protect themselves. And the defense has generally been found to be even less convincing where delivery without the production of BLs happens before the bank becomes a holder of the BLs. On the facts, however, the court found that the defense was not clearly unarguable here. This was because at the time that OCBC granted the trust receipt loan, it knew or was put on notice that the cargo would be blended by Hin Leong and on-sold as a different product to Pertamina. The circumstances surrounding the trust receipt loan, as we also looked at when covering the good faith point, suggested that OCBC looked to the proceeds of the sale to Pertamina rather than the BLs as collateral to secure the amount. So whether the trust receipt loan in this case amounted to OCBC's ratification of Hin Leong's instructions to the owner to deliver the cargo without production of the BLs was a matter which the court found should be investigated further at trial. So these were the two counts on which the owner managed to defend OCBC's misdelivery claim. Similar themes come out in the next decision, which I'm going to cover now, although dressed up under a different legal head of causation. So very quickly, the facts of Merck, the general structure and flow of the financing and the flow of BLs is roughly the same. We have a ship owner here. In this case, it was Merck. The charterer also was Winson, who had sold goods to Hin Leong. Hin Leong, in turn, had gotten a financing from Stanchart, SCB Bank. And Hin Leong was supposed to sell the cargo onwards to its buyer. Now, a couple of facts here, which are also very relevant to the court's decision. The sale contract here between Winson and Hin Leong provided for a delivery window of 21st to 25th February. The vessel arrived at the Universal Terminal in Singapore, which was a facility which was partially owned by Hin Leong, on 27th February. And the discharge took place on 28th February and was completed on 29th February. Delivery, unsurprisingly, to Hin Leong was without the production of BLs. Now, on 3rd March, that is after delivery had happened, Hin Leong applied to Standard Chartered Bank for an LC in favor of Winson. The application provided that the LC was for cargo which was to be delivered on DES basis at Universal Terminal, and the latest delivery date is, I quote, NOR tendered at discharge port 29th February 2020. The very next day, Stanchart issued the LC, and it also provided that the latest delivery date is, I quote, NOR tendered at discharge port 29th February. So it seemed that the LC itself was acknowledging expressly that, or at least a suggestion could be made that discharge had already happened by the time the LC is being applied for. Now, under the LC, payment was to be made upon Winson's presentation of BLs endorsed to the order of Stanchart, and if BLs were not available, it was to be made against Winson's presentation of a commercial invoice and an LOI. Of note, Winson's LOI, much like in the earlier case, was to be addressed to Hin Leong, not to the bank, and it was expressed to be given in consideration of Hin Leong having agreed to accept delivery without being provided the BLs, and the LOI contained an express clause excluding the rights of third parties. Winson presented the commercial invoice and LOI, and Stanchart paid it out under the LC on 27th March. Over 3 months later, on 7th August, and this is after Hin Leong's financial situation became public and judicial managers had already stepped in, Winson, through its bank, delivered the BLs endorsed by Winson to Stanchart onward to Standard Chartered. 19th November 2020, Stanchart demanded delivery of the gas oil from Merck. Merck could not deliver, and Stanchart made a misdelivery claim against Merck to the tune of US 6.1 million. The assistant registrar of the Singapore High Court granted summary judgment, and Merck's focus on the appeal was on one narrow issue, which was of causation, that is, whether its delivery of the gas oil to Hin Leong on 28th and 29th February without the presentation of the BLs had caused any loss to Stanchart. And the High Court, reversing the assistant registrar's decision, found that Merck had raised tribal issues as to whether its misdelivery had caused any loss to Stanchart. Now, in considering this issue of causation, the court had regard to one fundamental question, that is whether Stanchart regarded the BLs as security to begin with. And this in turn required examination of the precise financing and security arrangements between Stanchart and Hin Leong, as to which the court found that two issues of fact arose, which required further examination. First, whether Stanchart knew that whether Stanchart knew that the gas oil had already been discharged to Hin Leong when it accepted Hin Leong's LC application. And second, what exactly were the specific financial arrangements between Stanchart and Hin Leong. As to the first question, the court found that it was certainly arguable that by the time Stanchart had agreed to finance the purchase of the cargo, it knew or should have known that the gas oil was already in Hin Leong's custody. And this was by reference to the fact that the LC itself identified the latest delivery date as being 29th February. Stanchart did try to argue that the reference to 29th February being the latest delivery date was far from clear. But the court said that that wasn't determinative for the purposes of a summary judgment application. It, at the very least, had given rise to a dispute of fact pertaining to Stanchart's state of knowledge as at 3rd and 4th March when Hin Leong applied for and Stanchart issued the LC. Now, if Stanchart knew that the cargo was already in Hin Leong's custody, that could arguably indicate that Stanchart did not regard the BLs as security because it could not, in that case, expect the BLs to remain the keys to the warehouse, or that Merck would deliver up the gas oil once it was presented with the BLs. On the second issue, that is examining the financing arrangements, the court took note of a couple of points which could be gleaned from the financing arrangements. The first of which was that the facility was described as an unsecured facility. It was described as import LCs unsecured, and its purpose was stated as, I'm quoting, issuance of documentary LCs against pre-sold contracts from buyers listed in approved buyers list. And it also stated that the issuance of the documentary LCs was against unsold goods, and it was not to exceed 80 million. So the court said that looking at it, it would appear that Stanchart might have been aware that it was financing a cargo which remained unsold by Hin Leong, and the limit of 80 million would suggest that Stanchart was prepared to grant unsecured financing to Hin Leong for unsold goods up to a certain amount. Now, the meaning of unsecured naturally was quite hotly disputed by parties, but for the purposes of summary judgment, it was sufficient that there was a credible dispute on what the word meant and whether unsecured meant that BLs were also not being regarded as security for this financing. The second feature, it was that Stanchart had argued that the facility Stanchart argued that the facility required the full set of BLs to pass through the banking channels, hence indicating that Stanchart was looking to the BLs as security. Merck, however, highlighted a term in the facility which dealt with cases where the BL is not received by the bank, hence showing that Stanchart did not always require the BLs. Next, much like the OCBC case, Hin Leong had also requested a trust receipt in this case for a month from 27th March. But in response to this application for a trust receipt arrangement, Stanchart had granted an import loan of 31 days from 27th March, which effectively extended the time for Hin Leong to repay Stanchart. Now, when granting this extension as well, much like OCBC, Stanchart did not ask for any security for this loan, suggesting that Stanchart, to the court found, may have been aware that the gas oil was unsold and Hin Leong was requesting for time to sell it before repaying the loan. It also suggested that Stanchart was willing to assume the risk of Hin Leong's default without any recourse to security. Next, the court considered it relevant that the LOI only required Merck to send the BLs to Hin Leong and not to Stanchart. And it seemed that Merck also argued that it was perhaps only because of Hin Leong's financial difficulties that Stanchart was making this misdelivery case. It otherwise had no intention to call on or demand the cargo. Finally, the court also took note of two further factors. That is, under the LOI, which was directed to Hin Leong, Stanchart was arguably not even entitled to enforce the LOI and demand the delivery up of the BLs. And the fact that Hin Leong was a long-standing customer of Stanchart merited further investigation as to what exactly Stanchart knew about Hin Leong's business model and how long Hin Leong would be keeping the goods for before it would be able to on-sell them. Taking all of this in the round, the court found that a tribal issue had been raised as to whether Stanchart was looking to the BLs as security at the time that it financed Hin Leong. And so for that reason, Merck was found to have raised a triable issue as to whether any misdelivery that it may have done had caused Stanchart any loss. That's that for the Singapore cases. I'll hand the time over to Adam, who will now take you through the 2 English cases on misdelivery.
Thank you very much, Raman, and thank you everyone for joining. The first case is UniCredit and Euronav. So this is one of those classic trade finance misdelivery claims where a trade finance bank, in this case UniCredit, brings a claim against a vessel owner in its capacity as lawful holder of a bill of lading. Now, this is a case that was handed down earlier this year. It is currently under appeal, so watch this space as to what happens next. But this is English law as matters stand. So let's get into it. Next slide, please. I'll just give you some brief background. This was all about a vessel called the Sienna, which was chartered by owners Euronav to BP under a time charter. BP sold a cargo of low sulfur fuel oil to Gulf Petrochem, again, a name which many of you will be familiar with over the last few years, I'm sure. The cargo was shipped on board the Sienna. Gulf Petrochem paid for the cargo by way of a letter of credit opened by UniCredit. The cargo was to be resold by Gulf Petrochem to sub-buyers approved by UniCredit on terms requiring those sub-buyers to pay UniCredit directly 90 days from presentation of payment documents. So it's a classic kind of self-liquidating structure. UniCredit pays the sellers of its own customer, and in return it gets payment directly from its customers' buyers in due course. Next slide, please. So this is what happened in the actual event. So on the 19th of February 2020, the bills of lading were issued by the Sienna. On the 1st of April, the letter of credit was opened on application by Gulf Petrochem in favour of BP. On the 6th of April, the charter party, which BP had entered with owners, was novated from BP to Gulf Petrochem. Now, that's very important in the context of this case, and I'll come back to that in a moment. Between the 26th of April and the 2nd of May 2020, the cargo was discharged from the Sienna by STS onto 2 other vessels, the Kutch Bay and the Prestigious, against an LOI. So again, we have a situation where original BLs are not available, discharge is made against a letter of indemnity. On the 7th of August, BP endorsed the bill of lading to UniCredit, so some time after all of these events had transpired. And in the event, UniCredit had not been paid either by the sub-buyers or by Gulf Petrochem, so in the usual way, it's looking around at its securities, it's looking at what claims it may have, and ultimately brings a misdelivery claim against the owners of the Sienna in its capacity as lawful holder of the bills of lading. Next slide, please. So there were a lot of interesting issues in this case, but I'm just going to focus on the 2 main issues which the case turned on. One of those relates to causation. That's the second issue, and that's the sort of issue that Raman has been talking about in the context of the Singapore cases. But another important and interesting issue relates to this contract of carriage point. Did the bill of lading contain and/or evidence a contract of carriage on or after the date of the novation? So as I mentioned, BP was originally the time charterer of the Sienna, but at some point in time novated its interest in that time charter to Gulf Petrochem. Now, the parties all agreed that in the hands of a charterer, i.e. BP, a bill of lading is a mere receipt. I'm not going to get into too much technical jargon and stuff around what a bill of lading is in terms of, you know, its 3 main functions. The basic point here, which all of the parties agreed, is that where you have a party who is a BL holder and is also the charterer of the vessel, it is the charter party which is the contract of carriage between that party and the owners. It's not the bill of lading. The bill of lading in that context is a mere receipt for the goods. It just shows that the goods have been put on board. BP obviously ceased to be charterer when it novated the charter party to Gulf Petrochem. So it's effectively given away its contract of carriage, which it had with the owners of the Sienna. So that gives rise to a question as to where is the contract of carriage now? Is there a new contract of carriage between BP and the owners? What happens when that bill of lading is subsequently passed through the sale contract chain, through the banking chain? Now, it was also agreed generally that where you have a charterer who is also a BL holder, and that charterer endorses the bill of lading to a third party, a new contract of carriage effectively springs up between that holder and the carrier. So the bill of lading starts to take effect as a contract of carriage. However, we had a slightly unusual situation here in that before the bill of lading was endorsed by the charterer to a third party, the charterer gave up its contract of carriage. It novated away the charter party. So the question here was, what is the effect of that? Next slide, please. And I think somewhat surprisingly, the court held that the bill of lading did not contain a contract of carriage between owners and BP after the date of novation. BP had novated away its contract of carriage, and the bill of lading in those circumstances didn't magically become a contract of carriage between owners and BP. The court said there was no reason to conclude that the parties intended their relationship would be governed by the terms of the bill of lading where the charter party had been terminated. And they said this idea of a new contract of carriage springing up as it normally does where a charterer endorses a bill of lading to a third party is different from saying a contract of carriage is merely suspended and can be revived at a later stage. So having found that there was no contract of carriage evidenced by the bill of lading, by the time it got to UniCredit, it still was not a contract of carriage, and therefore the claim against owners failed on the basis that the bill of lading didn't have that characteristic of being a contract of carriage. I think it's a very surprising outcome. As I say, it is under appeal. I think it has a whole host of issues. Perhaps we can save those for the panel discussion later on, but that is the law as it stands today. Next slide, please. So the second issue is around causation, which, as I say, is all the sorts of issues that Raman has already spoken about. In the usual way, owners are arguing that it wasn't the misdelivery or the delivery without original bills of lading that caused the loss. The loss was suffered because UniCredit authorised, approved, requested or permitted Gulf to arrange delivery of the goods without the production of the original bills of lading. Now, in response to that, UniCredit said it did not give permission to discharge without production of BLs generally, and it certainly didn't give specific approval for delivery to take place by STS as opposed to delivery on shore. And there was a whole lot of factual witness evidence around what UniCredit knew, what it intended to do, what it would have done, etc., etc. Next slide, please. And it was held on the evidence that UniCredit did permit and would have permitted discharge without original bills of lading. UniCredit would have permitted discharge by STS. If UniCredit had been aware that discharge was by STS, it would not have halted discharge and the loss would have occurred in any event. So again, we're getting into these issues of causation of the loss. What is the true cause of the loss? Is it the fact that owners discharge goods without production of original bills of lading, or is it because the bank had set up this structure or acted in a way where they had effectively consented to this always happening, such that the bills of lading in their hands never really had much significance? They didn't regard them as being the key to the goods. They never intended to take delivery of those goods. And the court said it was inherent in this financing structure that discharge would be without bills of lading and that the endorsed bill of lading would not be available at the time of discharge. And therefore, UniCredit focused more on this issue about discharge by STS as opposed to discharge generally without productions of bills of lading. And the court was quite interested in that point. And I think they accepted to a certain extent that discharge by STS was somewhat unusual. But they said this was during COVID. There was evidence that, you know, there was port congestion, it was difficult to get to ports, and therefore there was an uptick in discharge by this methodology. UniCredit themselves accepted that a number of cargoes in which they had an interest had been discharged in this way. So whilst it was unusual in the grander scheme of things, at this particular time, during the height of COVID, this was entirely normal. And on the evidence, they said UniCredit, even if it had known about the discharge by STS, would not have halted the discharge. And so UniCredit lost, firstly, on the contracted carriage point, and secondly, on the causation point. As I say, that is under appeal, so watch this space on that one. Next one, please. The second case, a slightly older case, Finbank and Discover Investments. The Nicker was the vessel involved there. I can run through this one relatively quickly. The underlying finance scheme on this one was as follows. AOS Dubai's sellers would receive payment from Finbank against original bills of lading. So in the usual way, AOS has a financing line with Finbank. Finbank gives credit, pays the seller of the goods against original bills of lading. The structure after that becomes somewhat convoluted, but I've tried to keep it as simple as I can here. Finbank would forward the original BLs to a collecting bank in Egypt with instructions to transfer them to AOS Dubai's end buyers on a cash against documents basis. Cargoes would be discharged from the vessel without production of original bills, and then they would be transferred to a bonded warehouse. And they would stay in that bonded warehouse for potentially an extended period of time. Once AOS Dubai had paid for the goods, it would collect the original bills from the collecting bank and would take the goods out of storage. So in essence, you had the bills of lading which were held either by the bank or by a collecting bank on the bank's behalf until it had received payment. But that could obviously be a long time after the goods have actually been discharged from the vessel. Next slide, please. So again, a brief summary of what actually happened in the event. 22nd of March 2018, the bills of lading were issued for the carriage of wheat from Ukraine to Alexandria in Egypt. April 2018, the vessel discharged at Alexandria to AOS Egypt, and the goods were consigned to a bonded warehouse in the way that had always been intended. 16th of April, the bills of lading were sent to a collecting bank, and then in this case, the cargo was actually delivered out of the bonded warehouse against production of forgeries of BL. So some bad actors had come along with fake documents and they had taken delivery of the goods from the warehouse, not with the original bills of lading, which was still sat with the collecting bank, but with fake bills of lading. And in the usual way, Finbank is looking at what documents it has, looking at what securities and which claims it may have, and decides ultimately to look to the vessel owners. Next slide, please. Now, interestingly, this wasn't actually a case on the merits of the misdelivery claim. This was actually an application by the bank for a freezing injunction against owners in order to secure a misdelivery claim to be brought in due course. However, as a matter of English law, a requirement of obtaining a freezing injunction is demonstrating that you have a good arguable case. So in order to get security for your eventual claim, you need to show that your claim is a good arguable case. Now, the interesting thing to note about that is that you don't have to show that you're going to win the case eventually on a balance of probabilities. All you have to show is that you have a fairly decent case. You have a case which is not obviously terrible. So that was the only standard that the bank had to meet in order to satisfy this criteria of a freezing injunction. And look, there were issues with other criteria relating to the freezing injunction application in this case, but for the purposes of today, this requirement to have a good arguable case is the key. And it was held here that the bank did not have a good arguable case in misdelivery against owners. Again, we came back to this issue of causation. The delivery against a letter of indemnity was not causative of the loss. The agreed arrangements were accomplished up to the point the warehouse released the goods against the fake documents. If you looked at the financing scheme, everything went entirely to plan until someone turned up with fake documents and stole the goods. The goods had been discharged without original bills of lading. That was always intended. The cargo was transferred to bonded warehouse. Again, always intended. The collecting bank held the original bills of lading. What went wrong was that someone decided to fake the documents, turn up and steal the cargo, which is obviously unfortunate. But the court said, well, that's not really owner's fault. From owner's perspective, they had discharged against a letter of indemnity. As far as they were concerned, they'd put the goods on barges and waved goodbye to them. They'd given up control over the goods at that point. And it cannot be said that that was causative of the bank's loss, and therefore the bank lost on the causation point in this case. That's it for the English cases. I think we're now going to open it up for a bit of a discussion.
Thank you, Adam. Excellent. Yes, we'll have, just want to remind the audience, feel free to ask your questions through. We'll have a panel discussion between the three of us now on some of the themes that come out of these cases. In the meantime, if you have any questions, send them through and Raman will take them up. I guess Raman has some questions for Adam and myself.
I do. Okay. The very first question. The ship owners have previously tried to defend misdelivery claims by arguing that the lenders have consented to discharge without the production of BLs, but they've rarely succeeded. What do you think has changed with these new cases?
Adam, I'll let you do. Okay, I'll take it since you're on mute for the moment. My answer is actually not very much. The fact pattern don't seem to be very different from the last 2 years as it was 5, 10, 20 years before. Yes, they are unique facts, but it seems to me that the defense of consent has been resurrected through another means of a legal argument. So in the OCBC case, they talked about holding the BLs in good faith. In the MERS case, in the Standard Chartered MERS case, they talk about causation, and the misdelivery didn't cause your loss, it was something else. It all boils down to the same fundamental narrative, whether you're talking about defense of consent, whether you're talking about causation, not causing the loss, whether you're talking about holding the BLs in good faith. It all boils down to the same bottom line narrative, that you did not treat the BL as security. And how you treat the BL as security, I think we can come to that subsequently, but that seems to be the same. There has been, I think the courts appear more sympathetic when the same argument is put forward to them under the head of causative loss or under the head of holding the BLs in good faith. Adam, what do you think?
Yeah, similar. I mean, I don't think the facts underlying a lot of these cases have changed too substantially, but obviously the court's attitude towards them has changed, and they've obviously shown in these few cases more willingness to look at the factual background to these cases and to look at this issue of causation. Now, from a pure kind of legal perspective, you know, that appeals to me as a lawyer. I think that you have to look at these causation issues and you need to look at the facts and all the rest of it. I can see it becoming quite a big commercial issue, because obviously in the past I think the banks have not had to worry so much about the value of the bills of lading and the capacity in which they're holding them, because, you know, five years ago or more, if you bought a misdelivery claim against a vessel, they would say, can I see the original bills? And as long as you can show them to them, they'd probably think, okay, well, I'm stuffed. You know, it's really hard to defend a misdelivery claim. I think now you're going to see a lot more scrutiny around the original bills, but beyond that, around the financing structures, around the bank's intentions, around, you know, the commercial intentions behind the whole deal and structure, and what the bank really intended to do with those bills, if anything. So I think it does open up those sorts of questions, and I think we're probably going to see a lot more similar cases where people are really scrutinizing the factual background, as opposed to, as I say, to saying 5-7 years ago they would just say, do you have the original bills? Yes. Okay, well, let's settle then.
Robin, I think you're mute on your mic. But Adam, to your point, I think 5-10 years ago, if a client came, you tell me if you feel the same way, but if a client came to me, original BLs were with the bank, they want to go against a ship owner, I would sort of say there's no point fighting it. It's a lost cause.
I think that's right. I mean, we had a case about 4 or 5 years ago where we went to a QC, now a Casey in London, and said, you know, we've got this case, we think we have some arguments about causation, and we think, you know, the bank knew or should have known what was going on, and he said, forget about it, basically, at that stage.
Okay, so holding on to the BLs is not going to be enough. What more can banks do to make their misdelivery cases smoother? Are there any common takeaways from these cases which the banks can perhaps pay heed to strengthen their misdelivery cases?
Okay, I'll take that first again then. My view is this: you put it in two buckets. You look at your conduct, and then you look at the financing documents. So your conduct, and this might sound commonsensical, but when you're doing trade finance, I think the speed of trade finance, you're not applying you're not taking a step back and applying that thinking to the whole trade structure. The one takeaway I have for banks is that the BL is not a checklist document. You don't go through your trade finance checklist and say BL tick, and as long as the BL comes back at some point in time, life is good. That's not how it's that's not how it should work, and that's not the way it's going to work going down the road as well. So if at the time you are issuing where the bank is issuing an LC and it knows the cargo has been discharged, a bit like in the MERS case, tricky. I mean, are you really then relying on the BL? The BL, is what value is of the BL at the time the cargo has already been discharged, at the time you're issuing your LC. The other point would be that blending of cargo, which was in the earlier case of OCBC, that to me is another red flag. The moment the cargo is being blended and that checklist comes back to you, tick BL, yes, not good enough. I mean, if it's a security, the cargo has got to correspond to that BL. So if you've blended the cargo, it's a new cargo, you need a new BL. That's that constant thinking, and I think you need someone in the ops team in the banks to keep looking at this at every point of time, to see each time you extend a loan, each time you issue an LC, each time there's movement of cargo, you need to ask the same question. Is this document I'm holding on to, or I hope to hold on to, will this be the security that I hope to get? Things like, that's on the conduct side, right? The second bucket will be on the financing documents. You've got, if there's language in the financing documents talking about unsecured facilities and so on, then it's going to be tricky to say, no, it was secured. The BLs was my security. That the language betrays you. The LOI itself, the LOI is a tricky one, because the LOI, when they talk about letters of indemnity, that's typically addressed to the traders. You want it addressed to the bank instead, because then the bank would say, no, I wanted my BL and I couldn't get my BL, so I got an LOI addressed to me instead. That was how important I felt the BL was in the finance structure. And then there's the trust receipt mechanism. I think when you're using trust receipts, it really shouldn't be in substitution of the original BLs. And I think the moment you let the BL go back out into the real world, put it that way, you got to think about whether you're doing anything to act inconsistent with the rights of a security holder. Adam?
Well, I think you've covered it very well. I don't have a huge amount to add to that. I mean, as you say, I think one of the big things is really thinking about how important the BL is to you and to your structure. And if it is important as security, make everyone aware that it is important in the facility, in your dealings with other parties, because I think the sense you get from these judgments is that, some people treat it as another piece of paper on a checklist, as you say, and it is a piece of paper, but it's a very important one, particularly if you do need to call on it. So make it very clear in your structuring how important it is, make it clear that it is needed for security. I think there's going to be some issues around, how the timing of these facilities work. Some of those English judgments talked about the fact that, you were only ever going to get paid at best in 90 days time, which is going to be a huge amount of time after discharge. Can you really tell me in those circumstances that you were going to take delivery of the goods in the meantime, or prevent discharge in the meantime, and allow 3 months of demurrage to rack up until you got paid and said, okay, here are the original bills? Some of those arguments are going to be much harder to make now. So financing terms in terms of the period, as well as the terms of the facility themselves, I think are going to be an area for focus, particularly for owners who are trying to defend these claims.
Thanks, Adam. We've got some questions that have come in. Maybe I'll take them. Or Raman, do you want to take them?
Sure. Okay, so one of the questions we have is, if I could just summarize the question, do you think the use of EBLs will make us see fewer of these cases?
Adam, I'll let you have a crack at that.
Okay, EBLs. We've spoken a lot about EBLs in the past 2 years. I mean, for two reasons really. I mean, the first is because we had all these cases where you had fake documentation and things like that, and the second was purely during COVID, a way of moving documents around. We had a bunch of cases where, you know, there was lockdown in countries and you physically couldn't courier documents. So people are talking about moving on to electronic platforms. I mean, it seems, as far as I can tell, and I'd be interested in Baldev's experience, it seems that talk has died down again. You know, we seem to have that talk periodically. I'm a supporter of EBLs in principle. I think they solve quite a lot of issues. I'm not convinced they completely get rid of this sort of issue. Now, obviously, what they do is they cut down on transit time. So, you know, if it takes 3 days to get a BL from one country to another, you eliminate that because you endorse it on the system and then it effectively is with another person. It eliminates that. What it possibly doesn't eliminate is banks or other unpaid parties sitting on the bills of lading because they haven't been paid. So even though the transit is quicker, you may still have situations where they don't make their way through a banking chain or a sale contract chain because someone is waiting to be paid. So you could well still have the same issues. And then you're still going to have a vessel arriving at the discharge port. The original BLs, as represented by EBLs, are not available to the end receiver, so they can't present them for discharge, and you end up with an LOI anyway. So I think you could still have that situation. I think almost oddly, an owner may even be more reluctant to accept an LOI in circumstances where you have EBLs, because, you know, an owner can generally believe that a bill of lading is stuck in a system somewhere, it's stuck in the post somewhere. But if you're dealing with EBLs and you get a request for an LOI, an owner might say, well, the only reason this could be is because someone hasn't been paid and is sitting on the bill. So I'm not going to discharge against an LOI in these circumstances because there's a high probability I may end up being sued. So I think they do solve a lot of issues. I don't know that they completely solve this issue, although they probably do to an extent. But Baldev, very interested in your views.
Similar. I think when I started the webinar, think of it as two streams, right? The BL shows up in the financing stream, and then it shows up in the operational stream of moving through the vessels. So in theory, you hope that EBLs means that it arrives to the receiver in time. He can then use his glorious electronic document, and then you get a discharge. The holdup would be anyone, as you mentioned, anyone who isn't paid. Typically in the flow, I guess each bank will say they're taking a credit risk on not a credit risk. Their downstream bank is paying that. So the last one down the line would be the receiver, the receiver's bank. The receiver's bank would say, I've got the EBL. Well, and do I give it to the receiver? Receiver saying, please give me the EBL. I need the EBL to then go get the goods off the ship. And then the receiver's bank might say, well, you haven't paid under your facility. So until you pay, I'm not releasing it. And then the receiver will turn around to the ship owner and say, let's do it by letter of indemnity. Good old trusted letter of indemnity that's been going on for years and years and years. And I suspect that's where you're going to get these hiccups, because the EBL will struggle to be effective on both streams at the same time.
Okay, we have a few more questions from the audience. I'll read out one of them. Is there any value in obtaining the BL subsequent to financing against LOI if the BL is received after the cargo is discharged?
Okay, I'll take that then. There's a common misconception that being the lawful holder of the BL is not assessed at the time you receive the BL. It's assessed at the time, because there's this question of BLs being spent. by the time you got the BL, the cargo was long gone, the BL is worthless, sort of thing. And that's not the correct legal assessment. The legal assessment actually is that the rights created by the BL was created well before, was created through the financing. So as long as your financing document was created before the goods got discharged, yes, I think there is value in getting the BL. And once you are getting the BL, and the BL's rights should subsume with the lawful holder to sue and bring a misdelivery claim.
Okay, the next question is quite long, but I think the answer should be quite short for that one. I'll read out the question. It concerns a hypothetical scenario. If the goods are discharged against an LOI and the buyer refuses payment against an import document collection, including the full set of bills of lading, on the basis that the buyer wanted to apply a set-off in an other separate transaction with that same supplier, who did not send the full set of bills of lading, will the financing bank in that situation have a misdelivery claim against the owner of the vessel? I would think yes. The fact that the buyer may have a set-off against the seller is going to be quite irrelevant to the claim against the owner under bills of lading. So long as bills of lading are issued for that particular cargo, for that voyage, and the owner doesn't deliver against the presentation of bills of lading for that cargo, regardless of the reason for such misdelivery, I think the owner would be exposed to a misdelivery claim. Do you guys have?
I think you've answered it. And we've got 2 minutes to go. We've got one more question that we can take. I'm going to hand the floor to Adam on this. EBLs, once again, they talk about the changes in the law. In Singapore, they've passed a version of the, let me see if I can pronounce it right, the Model Law on Electronic Transferable Records. Yes, I think I got it right. And in the UK, they've done the same thing as well. Basically, the laws in the UK and in Singapore will recognize electronic documents. It has been said that that was the stumbling block towards EBLs taking off. Adam, what's your view on that?
I think it certainly was a stumbling block. You know, I'm all for it. As I say, I'm a supporter of EBLs. I think it's good to see countries moving towards accepting them. I think one of the issues is until you get widespread adoption of that, you know, in all the kind of key trading hubs, the key shipping hubs, people are still going to be skeptical of EBLs, because whilst a shipment from England to Singapore, you know, you're going to be okay. If you have discharge somewhere else where they haven't adopted this sort of legislation, I think people are still going to be worried about enforceability. You know, there's a lot of legal aspects to EBLs. There's how you deal with it on the platform terms. There is the laws of the jurisdictions involved, where it's shipped from, where it's being discharged. So I think it's a key part in the process, actually, having more widespread adoption of recognition of electronic bills as being equivalent to paper bills. So I'm certainly supportive of it. There needs to be a lot more of it.
Do you see adoption happening down the road quickly?
No, not quickly. I mean, it's one of these things, isn't it? It's one of these things that comes up periodically, and Singapore and UK have made that move. I hope so. I hope it's one of these things that once it starts snowballing, it just grows and grows, and no one wants to be left behind. But I'm surprised, I must admit, by how few countries have actually done it so far.
My 2 cents worth on this is that like Adam, I'm a fan of EBLs. I think it's the way of the future. There are a lot of challenges towards it, and I'll give you one example. It's fine to talk about Singapore and the UK and the world that we live in and how discharge is done, but there are goods move in countries where the notion of electronic BLs will be scoffed at. I think if you go to a customs authority in Africa, in one of the countries in Africa, and says this electronic document is my requirement to take discharge of the goods, they would turn around and say, show me that piece of paper, because I've got a hard copy folder somewhere, and that's the only way I'm going to let you take the goods off the ship. So that it's challenging. It is the right step in the right direction. I suspect it's going to take a lot more time before it becomes market practice. Okay, I think we've just gone past 6 o'clock. We were asked whether this is recorded. This is recorded, and we're happy to send it on request to whoever would like to see it again. Adam, thank you so much for your time. Really appreciate it. Thank you for your insight on the English law cases. Raman, likewise, thank you for the Singapore law cases. Any questions, please feel free to get in touch with Adam or myself. Very happy to take any questions that you might have offline. Thank you, everyone. Have a good evening.
Thank you. Bye-bye.